is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. I'm David Watkin, an attorney in Montgomery County, Maryland. Today we explore land use law and focus in particular on the laws, practices, and procedures in Montgomery County. What is the legal basis for the government to restrict a private landowner's rights to develop his or her property, cut down trees, or build sheds, large structures, or even swimming pools? How are the zoning laws enacted? What is the purpose behind them? How can they be changed? What does a developer need to do to get its project approved? What is the role of the Montgomery County Planning Board? To answer these and other questions, we are joined by the chair of the Montgomery County Planning Board, Casey Anderson, who was appointed to the board in 2011 and became chair in 2014. Casey is an attorney, former congressional staffer, and community activist. He served on the boards of the Washington Area Bicyclist Association, the Citizens League of Montgomery County, and the Committee for Montgomery. We are also joined by Steve Robbins, a principal at Lurch Early and Brewer in Bethesda. Steve is a land use attorney representing prominent national and regional developers, contractors, lenders, and commercial property owners. He has been involved in many high visibility projects in Montgomery County. The Washington Business Journal named Steve the region's top lawyer for land use and zoning for his work in transit-oriented development. Steve, Casey, thank you for joining us today.
Pleasure to be here.
Thanks for having us.
Steve, let's start with just kind of the words that we're using so we know what we're talking about. You hear about zoning, you hear about land use, you hear about planning. What's the difference between those?
Well, David, zoning is basically the use classification that's put on a piece of property. Basically residential, could be industrial, could be commercial, agricultural, and then you have a use classification that is actually put on by in this case, our county council. Planning is basically taking the zoning classification and then taking an area of the county or a piece of property and planning for the use, looking at the use, taking the zoning standards and making sure that everything fits and works and operates basically with our plans that we have, the master plans, which we'll talk about, and the zoning ordinance, which essentially carries forth the standards that one must follow in order to develop.
And who creates the zoning and the
Well, here in the county, it's the Montgomery County Council, the 9-member body in Rockville, that basically takes the zoning ordinance. We just had, for example, a complete rewrite of the zoning ordinance in 2014, where the county council for the entire county, where the county council also with the help of the planning board, because they really started the process, completely rewrote the zoning ordinance, which took the use classifications, the industrial, commercial, and put all the development standards and all the uses that are permitted, all within what we call the zoning ordinance, which in my world is basically the most important document to follow in order to develop in the county. So it's the county council that actually legislatively adopts the zoning ordinance.
And the planning board, Casey, you're the chair of the planning board. What is the planning board? Let's start with that, and where does it fit into the mix?
Well, as Steve mentioned, the planning board makes recommendations to the county council about changes in the zoning ordinance and also about master plans, which are plans that govern specific areas of the county. For example, there's a master plan that covers the White Flint area. There's another master plan that covers the Shady Grove area near where we are right now. There's a master plan for downtown Bethesda, and another one for downtown Silver Spring. So each one of those master plans is drafted by the planning board and submitted to the county council for their amendment and approval. And then once those plans are approved, together with the zoning ordinance, they govern what can be built on specific pieces of property.
And that is for the entire county, the unincorporated part of the county?
The unincorporated part of the county, which means essentially everything except Rockville and Gaithersburg.
Okay. And what about state property or federal property? Is that
The
separate?
government property is handled a little bit differently. We have an advisory role with the state and federal government and the county government as to what they do with their property, but we don't regulate them with the force of law as we do with private development.
Okay, all right, we'll come back to that a little later. But what about, you hear about the Park and Planning Commission? How do they fit into the mix?
Well, I'm the chairman of the Montgomery Planning Board. I'm also the chair of the Maryland National Capital Park and Planning Commission,
Okay.
which is a bi-county agency that's created by state law that has its origins in the 1920s. It covers both Prince George's and Montgomery County, and the Montgomery County Planning Board exercises authority over Montgomery County. There's a similar body in Prince George's that handles land use regulation on their side. We also own and administer all of the parkland in both counties. So in Montgomery County, we have about 37 or 38,000 acres of county parkland. That includes things like ball fields.
It's like Cabin John or?
Cabin John Park is a Montgomery park, but it's also part of our Maryland National Capital Park and Planning Commission holdings. And
Wheaton Regional.
Wheaton Regional Park is another one. And
all the places where my son plays baseball.
Exactly.
that's right. If you play, if you or your kids play soccer or baseball or even cricket in the county, then you've probably played on one of our ball fields.
Okay, can't speak for cricket, but I do know the other ones.
Right.
Steve, so what happens? What happens if the planning board makes some recommendations that then go to the county council? Is that?
Well, if you're talking in the realm of the master plans,
Right.
like Casey mentioned, whether it's Bethesda, Silver Spring, White Flint, the planning process starts with the planning board, and the planning board essentially through their staff come up with a plan that's then the staff presents a plan to the planning board with, frankly, input from property owners as well. So if you own a piece of property that's in the Bethesda planning area, for instance, it's a great opportunity to get involved for the future of not only your property, but for the future of the county in this particular area. So you get involved, the plan is presented to the planning board. The planning board has work sessions after a public hearing. There's always public hearing before the planning board, has work sessions on the plan, and then as Casey mentioned, once the planning board essentially is done with their work, they send the plan up to the county council, and we essentially go through the process again, where there is a public hearing, and then the county council has their work sessions, typically through a committee of 3 council members, and then it goes to the county council for final approval and then back to the planning board for adoption. And then that's what you really have to follow together with the zoning ordinance if you have a particular project in mind for a piece of property to move forward. So you have to follow the master plan, and of course you have to follow the standards in the zoning ordinance.
And
So it's a very active board. A lot of issues are in front of them, and we appear regularly with clients before the planning board on what we're talking about right now.
okay, great. And Casey, so how many members are on the board?
There are 5 members. We serve 4-year terms, and I'm the only one who's a full-time member. So
Okay.
I that's my job. The other 4 are part-timers. Some of them are retired from other jobs. Some of them work full-time jobs in addition to serving on the board.
And so it sounds like a pretty laborious process. How long does it take from the time you start into one of these plans to the time it gets adopted?
Typically, it takes a couple of years. I would say at least a year on the shorter end, and sometimes as long as 3 or 4 years, depending on how complicated and controversial the issues are.
So once the plan goes through your group and then the planning board and then is approved by the county council, are you charged with kind of implementing it or overseeing the implementation of it?
That's right. As property owners move forward with the process of developing individual properties, they submit plans to our staff. Our staff reviews them, makes sure they comply with the zoning ordinance, as Steve had said, gets input from the neighbors, and then makes a recommendation to the planning board, and we approve or reject those plans. And at that point, if anyone is dissatisfied with their decision, they can take the issue to court, as opposed to with the master plans, those go from us to the county council. Once you reach the point where there is a master plan and a specific development application is in front of us, the review is by the court system instead of the county council.
So that'd be the circuit court for Montgomery
Right.
County?
That's right.
David, one thing I would mention on that is that the tie between the zoning ordinance and the master plan, in terms of the master plan having the importance that it does here in the county, they are really very important documents, is that many of the processes that we go through, the zoning ordinance specifically states that the project that you're showing the planning board and hoping that receives approval has to be essentially substantially in conformance with the master plan. There's a standard and a finding that the planning board has to make in most of these processes. So that links the master plan to the specific approval.
Okay, well, let's step back on that for a second, Steve. So if a developer were to come to you, as I'm sure they do on a daily basis, and ask, say I want to develop a piece of property into, I don't know, a multi-use
Sure.
building,
Sure.
whatever,
Something in White Flint.
Okay, perfect.
For example.
So what would be the process for doing that?
Well, we would take a look at the piece of property, look at the zoning, and typically the zoning on these mixed-use projects would be what we call the commercial residential zone, which was essentially enacted with the adoption of the White Flint plan and with the zoning rewrite that I spoke about. But take a look and see what the zoning is and see what the development standards are. And then, of course, one of the first things I would do is look at the master plan and see what is the master plan recommendation for the piece of property, to make sure that my thinking and our planner's thinking is in line with what the county council and the planning board had in mind for the recommendations on the plan. And I would get other professionals involved once we felt comfortable that, yes, this project made sense to move forward. We'd get land planners involved, we'd get civil engineers involved. Typically, we get a traffic consultant involved. If there are environmental issues, we also have environmental planners, all working together as a team with really the land use attorney, in my case, myself being sort of the quarterback of the team and working with all these professionals to not only address all the standards of the zoning ordinance, but also to make certain that the master plan was being followed, that we could come up really with the best project that we could, working together with the technical staff at the Planning Commission, and of equal importance with the community, presenting our plans to the community and making sure that there was buy-in to the project to the best of our ability, so that we presented a plan to the planning board that was in line with the thinking of everybody.
And then you make a presentation?
Make a presentation, and the board ultimately has the final decision on most of the processes that we go through.
How long does that, from the time that the developer walks in the door to the time that you're ready to present it to?
Used to take a lot longer. The zoning ordinance is now very specific on how long the board has to make a decision. And typically, from the time you file, the board has 120 days for the plan to get to the board and for the board to actually make the decision. It's typically 120 days, which is a good time frame in which to work out issues, work with staff, work with the community, and then present a project to the planning board that is hopefully wrapped up in such a way that the board feels comfortable approving. Wouldn't you agree?
I think that's about right. Sometimes complicated projects or projects that are so large that they're intended to be completed in phases can take
Pike and Rose, for example.
Pike and Rose is a good example. If you've seen what's going on at Pike and Rose, I was just driving by there today and noticed that they're up with they basically have, I think, topped out another building. Right. And you probably noticed the first phase of that project was done a couple of years ago, right. And then they wait until the market will support another building. And in the meantime, they may come in and amend their original plan and tweak it a little bit. So we may see the same plan come back several times over the course of.
I would say that's generally the norm, as opposed to the oddity, that if you have a major project like Pike and Rose or some of the ones that I work on, as you go through the process, ultimately you will amend at one point or another to either address field conditions or changes in the project or whatever.
Changes in the marketplace, perhaps?
It could be. I mean, that's a little more extreme. That's on a very long-term project, but there are things that you address that you thought were as accurate as you could get, but you need to either change or address, and there are processes for that.
And so Steve makes his pitch for this new project at White Flint, and then what happens, from your end of things?
The staff produces a written report for the board that we get a week before the public hearing. So we read that ahead of time to prepare, and then we hear an oral presentation from the staff. Usually the applicant or the applicant's lawyer, somebody like Steve, will make a presentation. If there's anybody opposed to the project, they make a presentation as well, and we can ask questions, and then we deliberate in public and make a decision.
And how long is that all? Is that a day, or is that many weeks?
Oh, that almost always happens on the spot.
Oh,
so
okay.
The hearings themselves can go on for 2 or 3 hours if the issues are complicated, and if there are people who are appearing in opposition. Sometimes it can take a while to work through those and decide the specific issues. In an uncontroversial case, for example, if you wanted to subdivide a large property into 2 or 3 lots, that might take 15 minutes. But it depends on how complicated the project is, and again, whether or not there's any public opposition to the proposal.
And the planning board is looking at both residential and commercial use,
Yes,
all types of
everything.
uses?
Right.
And what happens if, for example, kind of what Steve was alluding to, that there's a project that's approved, but as kind of it's going to be built in phases, but as the years go by, there's a change for whatever reason, the developer wants to do something different. They have to come back. They come back to you.
They come back to our staff and try to work through whatever the issues are, and then they submit it to us to approve an amendment to the original plan.
Okay, so we talked a lot about master plans, and the way I'm understanding, master plan is kind of like a subset, or the zoning is kind of the legal ordinance that kind of sets the framework, and the master plan is more of a specific.
Zoning's the law.
Okay.
Master plan is a guide.
Got it. And so how does that get approved? How does that whole process work?
Well,
The master plan part of it.
Oh, sure. Well, as we mentioned earlier, the master plan is basically approved by the county council sets the work program for the planning board. And we'll just use, for example, Bethesda. The planning board right now was just dealing with the entire Bethesda downtown district in terms of reviewing that with all the property owners and community input. That's that the staff comes up with their plan, and then the planning board reviews it. They put the icing on whatever they feel is the most appropriate thing for their plan, and send it up to the council, and the council then goes through all this again and is responsible for approving it.
And is it basically set in stone, or can it be changed as things happen? For example, something gets zoned a certain way, but because of market conditions or what have you, demand, supply, someone wants to do something different.
The zoning code provides for certain circumstances where a property owner can apply for a different zoning. Usually that's called a floating zone. For example, in a residential neighborhood, the master plan might say in a residential neighborhood that's abutting 355 or Old Georgetown Road, a major arterial, it might be appropriate at some point in the future to consider townhouses on the edge of a residential neighborhood. So the master plan might recommend that an application should be considered at some point in the future if a property owner wants to take advantage of that. And then there's a rather complicated process that winds up going back to the county council to get rezoning. But generally speaking, whatever the master plan says goes. And while it is, we try to write the master plans in such a way that they're flexible enough to deal with unanticipated events.
Sometimes you can't help yourself.
Well,
sometimes
sometimes we have to be specific because we have very particular objectives we're trying to achieve. And when the master plan is specific, it can have the force of law.
And if it's very specific, sometimes you handcuff yourself sometimes because master plans are only reviewed typically every 10 to 15, maybe even 20. There's some that are even 30 years out. So that's why there's a lot of painstaking attention paid to the master planning process. I would say that the majority of the applications that are heard by the planning board really are the day-to-day applications, whether it's a subdivision, a site plan, or what we all do now, which are sketch plans, which go with the commercial residential zone that I mentioned. Those are what I think you all as a board really deal with on they meet every Thursday, on an every Thursday basis.
Well, that's a good point. I think people should understand that typically you don't have to go to the planning board to tear down your house and build a new house, for example.
How about put a shed on your property?
You probably won't have to go to the planning board to put a shed on your house. You have certain development is by what's known as by right, which means that you do have to usually get a permit, some kind of building permit, and the Department of Permitting Services will go make sure that whatever you build complies with the fire code and the building code and fire and rescue access and those sorts of requirements. But your project is not reviewed by the planning board, and you're entitled to do that, which is why it's called by right.
You still have to get permits, though.
To actually do the work.
Yeah.
Right, but it's not discretionary that should you or should you not be allowed to build a shed in your backyard.
Right.
But you do hear, Steve, cases where people chop down, I think there was a case involving Dan Snyder chopping down a whole bunch of trees, and he got in trouble for that. What are the limits for private property owners?
Well, I think, and Casey can correct me if I'm wrong, but most of the cases that the planning board deals with in terms of these violations deal with forest conservation violations. And they arise from situations where homeowners in general have forest conservation easements placed on their property. Many homeowners don't even know that they have them. And these
forest
easements,
conservation meaning leave it alone.
meaning that there's forested area.
Forested or forced?
Forest area.
Okay.
That needs to, in some cases it is forested, meaning that you have to actually plant and then it grows into a forest. But generally a forest that is on your property, and there are requirements pursuant to an easement that's placed on your property where you can and can't do certain things. And people find themselves, some don't even know it, that number one, they have the easement, or number two, that they're doing something wrong, but they find themselves violating an easement, and that gets you into a situation where you then have to work with technical staff to provide corrective measures which must be approved by the planning board because they are the beneficiary of the easement, of this forest conservation easement. And those are sometimes very painful cases because there are situations if you have what's called a Category 1 forest conservation easement, which is the most restrictive, you're really not allowed to touch anything in that area. And there are times when homeowners don't know that they have it, and they're, for example, mowing the lawn within the easement. That's actually a restricted activity, and they hear these cases where the compensatory measures are and the corrective measures are to potentially remove the easement area and move it off of the property onto another, in some cases, more appropriate area. But there are ways to work this out, but the planning board is the ultimate decision maker in these type of violation cases.
Yeah, the forest conservation law, I think, is one of the most difficult laws that we administer because many people, as Steve said, don't realize that when their property was originally developed, there was a forest conservation easement placed on it to preserve to the maximum extent possible while still allowing for the development more or less as contemplated by the master plan and the zoning code.
So this is not like behind your property where you back up to a forest or something like that. This is actually
it's on your property, but it very well could be in what you think of as being your backyard.
Right.
So when somebody buys a house, they may not really think about it too hard. They may not examine their settlement documents very, very carefully. They may not ask to see the plat that shows where any easement might be placed.
Yeah.
And then so maybe they have children and they decide they want to put up a swing set in the backyard, or they want to put in a swimming pool, and they just go ahead and do it, and then one of their neighbors says, "Hey, I think you're not really supposed to be cutting down those trees," and then it creates a lot of conflict.
Okay.
It does.
So you could have
Which we resolve.
right.
Try to resolve.
So you could have a situation where the HOA is saying you need to cut the grass, and you cut the grass and you cut too much of the grass. Or
You know, I guess the HOA technically could say that, but it's more of a situation where the homeowner just thinks that they have the ability to do that, or clear out the understory and the requirements of the easement control.
Got it. Well, unfortunately, we're out of time. Casey Anderson, Steve Robbins, thank you very much for being with us today and helping us to understand the fundamentals of land use and zoning and planning laws.
Thank you for having us.
Thanks.
Please let us know what you think, as well as what topics you'd like to see on future programs by emailing us at lawschoolforthepublic@gmail.com, or feel free to email me directly, david@walkinlaw.com. Please join us for future programs in our Law School for the Public series. On behalf of the Bar Association of Montgomery County, I'm David Walken. Thank you for joining us.